Now, we're going to close out today's conference with someone who probably doesn't need an introduction to this group, but of course is entitled to one, and that's Alan Gernhardt. He's the Executive Director of the FOIA Council. He is, and he was the Associate Director for years before that, so he's been with that office since Methuselah, I believe. And he goes wherever he is required to go to do training, which has really increased lately because the General Assembly has added requirements for additional training for FOIA officers, as well as elected officials and members of economic development boards and so forth. So he also, though, always finds time to make time for me to noodle something over or give me, you know, some background on some information I might need. So Alan's here for a 1.5-hour training module on FOIA's records and meetings provisions. Now, this section is, of course, open to anyone who has signed up for this conference. But if you're a FOIA officer, and actually, let's just see who is. Oh, sorry, I have not done that. Let's see who is a FOIA officer here. But if you are a FOIA officer, this training by Alan will satisfy the training requirement of 2.2-3704.2. And if you're an elected official or a member of an economic development board, this will satisfy the training requirement of 2.2-3704.3. So again, Alan and I will both be monitoring the questions. He's very good at incorporating those into his presentation. And for some of them, I'll be able to type in a quick answer where it's appropriate. So there's our breakdown what is that? So more than half the people on the call right now, Alan, are FOIA officers. So we have a good audience, and I hope for those who aren't FOIA officers that this will be really helpful so that everyone understands the messaging that everyone else is getting. And hopefully that as requesters out there, it'll help you when you are making requests of your local or state government. So, Alan, let's ask you to unmute there, and let's put you on spotlight.
All right. Good afternoon, everyone. So I had actually set up a virtual background, but it didn't come through, so you get to see my man cave. Behind me, you have my Slayer posters, Black Sabbath. In the mirror, you got Iron Maiden. That's Venom over there. So these are all my high school posters. Go ahead and throw that out there because, as someone else said, you know, as we're doing all these virtual telecommunications things from COVID-19, you're getting to see everybody's house and their backgrounds and all that stuff. And I think I have the most colorful room because I rebuilt my room from high school. I saved all these posters. I still have them, so I decided to go ahead and put them up. So that's what you're looking at in the background. That said, I'm going to go ahead and share my screen. Let's see, let me get over here. And, for some reason, there we go. I'm getting the proper thing up. Because what I'm going to share with you today, let me try it again. I didn't share it properly.
Is it?
There it is.
Okay.
Yeah, it wasn't loaded all the way, I guess. So let me see. Can everybody see the PowerPoint homepage here, Virginia Freedom of Information Act for local elected officials?
Yes.
This is the PowerPoint version of the new training module. I want to take just a moment to talk about the training options we've got. We have an online version of this training module that's completely automated. You can take it whenever you want. And unfortunately, it's been up since actually just before July 1, and some users have buffering problems. It appears to be random. I actually was communicating with IT again today. They moved it to its own server, And as far as they can tell, there are no server errors. There's no errors in the course. I've worked with the people who make the software we use to create the course. They tested it. They put it on one of their servers. Nobody has been able to find what is causing these buffering problems. So as of right now, I do not have a solution if you're having these buffering issues other than delete your history, delete your cache, try again sometime, maybe try a different browser. I'll tell you, I personally did the course on 3 different browsers yesterday. 2 of them crashed. Chrome and Firefox both crashed. I have successfully used Chrome and Firefox for the course on the same computer with the same connection at other times. The one that worked yesterday for some reason was Internet Explorer. No idea why. It's completely out of date. Microsoft doesn't support it anymore, but it worked. I don't have an answer at this point, but the course is up for those who want to try to take it. We are also trying to migrate it over to the Commonwealth of Virginia Learning Center. For those of you who are FOIA officers who have taken the current online training that's been around for a couple of years now, that's the one on COVLC now. We're hoping to migrate this course for elected officials over there, so there will be 2 different courses over on COVLC. For FOIA officers, I don't think it really matters which one of these you take. The difference between them is that the one for FOIA officers, since FOIA officers' primary job is handling records, it just addresses records issues, and that's all it really goes into. For this course, for local elected officials, we added sections on meetings and on remedies and penalties, as well as some additional resources outside the FOIA Council that can be helpful to elected officials particularly. So that said, let me get into this. All of them start with the contact information, which is probably the most important thing I can give you, because you've got all the resources on our website. You can always reach us by email, and you can call us. Right now, our office, I believe our latest order is we are teleworking through basically Halloween, October 31st. So if you call that main number, you're probably going to get a voicemail, and we will answer it as they come in, as we get them. But if you need to reach me directly, the best way is to call my desk phone, which is 804-698-1877, and that'll forward over to my cell phone as long as we're teleworking. And any other time, it'll just go right to my desk. So it's still the best way to reach me. Okay, that said, let's move on to the next slide. The contents of this training. We start with our introduction. We're going to go into a little bit about the FOIA requirements for local elected officials, and we can talk about FOIA officer requirements as well if anybody wants to. Then we get into the nuts and bolts of it, public records, public meetings, remedies and penalties, and then, like I said, other resources at the end. And I should mention, this course, as well as all our other PowerPoints and our handouts, is available on the FOIA Council website on our reference materials page. And you will see throughout this that the PowerPoint has a whole bunch of hyperlinks in here for the different code sections and other resources. So if you go to the PowerPoint, you can then reach out and get everything else online. So our introduction, start a little bit about the FOIA Council. For anyone who doesn't know and didn't hear everything on the kind words Amanda said and everybody else, FOIA Council's been around since 2000. I've actually been with the council since 2004. We exist to provide a legislative, well, I'll get to the slide. We're a legislative forum, and we answer questions about FOIA. We try to help people resolve FOIA issues without going to court, without the need for the formal action. Can't always do it because we are limited in that we're not a trier of fact and we're not an investigative agency. We don't have enforcement powers, but that's generally what we do, is try to help people understand FOIA and comply with it. We're also going to talk about the purpose and policy of FOIA. As most people here would already know, the general policy is openness for both records and meetings, and you can't withhold anything unless it's exempt. There has to be a proper records exemption or a meetings exemption. And the idea really boiled down is, what's government got going on? What are we doing? The people have a right to know. All right, next in our intro, we talk about the structure of FOIA. This is just to help people find what they need if they actually need to look at the code themselves. All the general provisions in the beginning, stuff like the definition section, things that are not subject to FOIA, the policy requirements for receiving a copy of FOIA if you're an appointed or elected official, the policy itself, all of that is in the first few sections. Records then is the next set of sections, and these training requirements for FOIA officers and for local elected officials and EDA, IDA members and directors are in the kind of with the record stuff there in 3704.2 and .3. That's followed by the meetings provisions, and then finally the remedies and penalties. About the FOIA Council, as I was saying, we are a legislative branch advisory council. We provide a legislative forum. I think it was mentioned earlier that this year we didn't originally have any bills referred to us, but it kind of came in a little late. We did get House Bill 321 from Delegate Levine, which concerns electronic meetings. We had our first meeting of the year, August 4th, and we are continuing 2 subcommittees so far. Well, recreating the electronic meetings one to study HB 321, as well as other electronic meetings issues. And we also started a phishing study last year that we'll be continuing. We are waiting for the special session to end before we schedule subcommittee meetings. And I should say, we're also going to offer additional live trainings. We plan to, but again, we're waiting for a special session to end before we do that. Other stuff we do at the council, we answer questions. This is probably the primary part of my job. Is every day I answer emails and phone calls from government, from citizens, and from media. Part of it is the way FOIA is structured. People are sometimes surprised. Most questions I get are from government. Citizens are a close second, but government's the majority and has been for years. But if you think about it, it makes sense because all the responsibilities of FOIA are on government. Citizens have very limited responsibilities in making requests, and none of the responsibilities to respond. So it's government that's usually concerned about, oh wait, I don't want to violate this. You know, I'll call the council and see what we're supposed to do here. Media, I think that's just a population factor. Media uses FOIA a lot, but they're a very small percentage of the users out there, so we get the fewest requests from media. Next, we do publish formal advisory opinions and educational materials. Like I said, our reference materials has a lot of handouts and PowerPoints. We have advisory opinions every year. We started out with a lot of them, but most of the main topics we covered in the first few years, I think, so we can usually refer back to older opinions for a lot of issues now, and so we're doing fewer formal advisory opinions, but contrasted to that, we've got a lot more informal opinions. We're typically up to, I think right now we're over 1,500 we've done so far this year, and we've got a couple months left before we do our annual report. So we're on track for the 1,700 to 1,800 or so per year. We provide FOIA training presentations like this one. And as I mentioned earlier, we are not an investigative or enforcement agency. Sometimes I do get people saying, hey, I have a FOIA complaint, you know, what are you going to do about it? And I have to tell them, well, I can place a courtesy call. I'm happy to talk to somebody on the other side and try to work things out, but I don't have any power to enforce FOIA. If you need to enforce FOIA, you got to go to court. All right, moving on to the purpose and policy of FOIA. As we said, we guarantee ready access to public records and free entry to meetings of public bodies to the citizens of the Commonwealth and certain media representatives, and we'll talk about that a little more in a minute. FOIA is one of the few laws that actually gives you rules of construction. It says you are to liberally construe everything in FOIA to promote awareness of government and activities and operations, except the exemptions have to be narrowly construed. So I call it the Johnny Cochran moment. When you think about exemptions, when in doubt, give it out. Keep in mind that an exemption doesn't stretch. You can't twist it or fold it or bend it around a record to try to protect something just because you want to protect it. You have to look at the way it's written, look at what the record is, and either it's protected or it's not. You don't get to stretch exemptions. They have to be construed narrowly. Next one, same thing with meetings, equal application there, and no record or meeting shall be withheld or closed unless it is specifically made exempt. So as I was saying, I did another training this morning for some people, and it's one of those, you know, kind of an attitudinal adjustment where you think about, you know, when we're in government, a lot of times, you know, you're writing something, you're doing something, you're going, hey, this is mine, I did this, and oh, I don't know if I want to give it out. Forget that. We're in government. We work for the public. When I create a record, unless it's something specifically exempt or made confidential by law, it's not my record, it's the public's record. The public owns it. This PowerPoint right here, yeah, okay, I prepared it, but I did it for the public. I did it for the people of Virginia. It is a public record. That's what public record means. So try to keep that in your thoughts, that everything we do by default is open to the public. It is supposed to be available because it is for them. Okay, that said, moving on. Let's talk a little bit about the requirements for local elected officials here. And I would note the constitutional officers are specifically included as public bodies in FOIA, but only for records purposes. Other elected officials can be subject to both records and meetings. And of course, for FOIA officers, your primary job is usually handling the record side of things, but you might be called on to help with meetings. And I would remind everybody who's listening who's in government, you're also a citizen, I bet. If you are, you may want to make a FOIA request. You might want to go to a meeting somewhere. I was talking to permit technicians, people who do building inspections, that kind of stuff this morning. And I remind them, you know, if you have kids, you might want to go to the school board meeting. You might want to request records from the school board, you know, at some point. You might be concerned about something your city council is doing, and you can still act as a citizen even when you're in government. So keep in mind, this is not just your responsibilities, it's also your rights. Okay. Specific requirements for local elected officials have to receive FOIA training from the council or local government attorney within 2 months of assuming office. I would note that since this is the first year this goes into effect, there are enactment clauses on the law that say any training from January 1 through December 31 this year will count for the first year's training. The training can be presented live or it can be online. You have to receive training again at least once every 2 years since the last training, and the clerk of the public body has to keep records of the training for 5 years. I do note you don't have to report your training to us. You only have to keep your own records. It's similar with the FOIA officer requirements. You don't have to send us copies of your certificates for training or anything. We don't need to have a copy of that. The difference for FOIA officers versus elected officials is for FOIA officers, we do maintain a FOIA officers list. So you are supposed to add your contact information and name to that list. For local elected officials, we don't have to maintain any of that stuff, and so we're really not tracking it. If anybody needs a list of all officials who have taken the training, you can ask me for it, but I don't have it. You'll need to go to the clerk of the body for those. Okay, continuing with requirements, and this is old requirement that's still in effect. Anybody who is elected, re-elected, appointed, or reappointed must be furnished with a copy of FOIA within 2 weeks. They have to read and become familiar with it. And if you need it, you can always get a current copy of FOIA from the council's website. It's always on the main page. I would also note other laws may also apply that affect access. Depends on what type of official, what type of record, the type of meeting, particularly as examples for local government. Typically for the governing body, you'll have a whole bunch of laws in Title 15.2. Some of them are specifically about meetings, regular meetings, special meetings. Some of them talk about public hearings. Some require specific types of notice, like publishing notice in your local paper, you know, other things like that. Those are going to be laws, you know, separate from, but in addition to FOIA, and they're a little bit different. School boards similarly have their own rules in Title 22.1. I think EDAs, IDAs are also covered in 15.2. So those are things to be aware of. For constitutional officers, you know, some of the big ones for those who deal with criminal records, they have to consider things like criminal history. For those who deal with tax records, for the commissioners of revenue and also for treasurers, they've got to look out at the tax code and the prohibitions there. And because our authority is limited to FOIA, you know, I will mention those laws if I know they're out there and I know they might apply. I will try to direct people to them as best I can. But when you need to interpret those laws outside of the context of FOIA, I can't do it. I don't have the statutory authority to do it. For that reason, I will always be directing people to their own attorney or the Office of the Attorney General when you have to interpret other laws. Let me see, did we get, I was looking, the top thing bounced out at me. I was just checking if there's Q&A, but I don't see any. Okay, moving on. We got through that. Okay, some examples of these, as we were saying, for court records, Title 16.1 and 17.1, the rules of the Supreme Court of Virginia, various code sections for local governing bodies, public hearings, school boards, and the tax section. All right, moving to the nuts and bolts of public records. This, as I said, this training is really designed for elected officials and members of EDAs and IDAs. So for them, the important thing is learning how to recognize and respond to FOIA requests. This one is a little less detailed, but still covers all the basics as compared to the FOIA training for FOIA officers. Okay, so we start again, remind everybody, public records are presumed to be open unless they're specifically made exempt. When we look at the definition of public record, I usually break it down into 3 different parts. First part, we've got all writings and recordings that consist of letters, words, numbers, or their equivalent, however stored, and regardless of physical form or characteristics. When we look at that, the important thing to remember there is we're talking about records. We're not talking about things that are not records. So if we have a conversation and no one records it, then it's not a record. There is no record. You ask me, oh, can I get a copy of your conversation? I'm sorry, I didn't record it. There is no record of that. On the other hand, if you do make a recording, then there is one. And this is where we can talk about the consequence of choice. Easiest example is two people working together and you have a choice of pick up the phone or, you know, outside of COVID-19, you could walk down the hall and talk to somebody. A lot of people now can't because of teleworking, but you could still pick up the phone and just chat with somebody, or you can send them an email. There is no right or wrong here. This is not a moral choice. This is not a good or bad thing. It's just be aware. If you choose to send the email, you're creating a record. If it meets the rest of the definition, it's a public record. So it might be subject to FOIA, may also be subject to the Public Records Act. If you have a conversation, there's no record. So that's just something to be aware of, the consequence of your choice there. I do see a Q&A question. You can get a copy of the PowerPoint. Actually, you can do it right now if you want to. It is on the FOIA Council website at the reference materials page. And I'm not sure if, let me see if I have a way. I don't know, Megan, is there a way, can you type that in, I guess? I'm not sure the best way to do it without.
Yeah, I'm not able to, well, actually, yeah. Send me the link and then I will put it, oh shoot, who just
Nope.
released that question?
I did.
Oh, Alan.
Hold on. And,
I'll get it back. Just
do.
Can you send me the link and then I'll type it in, or you can type it in too.
Yeah.
So
I go, this particular PowerPoint is on our reference materials page. And it is called Local Elected Officials and FOIA PowerPoint Presentation. And I'm going back to the meeting here. And let me see if,
Regina, can you type your question back in? And that way we'll have an open question that we can then paste the.
oh, here we go. How about if I go to the chat, I can send it to all panelists and attendees in the chat.
Okay.
And Amanda already had the link. Thank you. All right. Let me see. Okay. Are y'all still looking at the PowerPoint?
Yes.
Accidentally kill that. Okay. And PowerPoint. Oh, okay, Megan, you got that one? There you are. Okay. All right, so moving on with definition of public records. As I was saying, you know, it's any type of record, and the consequence of your choice to make a record is, okay, you've got a record, might be subject to FOIA, might be subject to the Public Records Act. As a consequence of this, keep in mind things like social media and email. If you use a personal account, if you use your home computer, if you publish something on Facebook, that's a record. If it meets the rest of the definition, it'll still be subject to FOIA. So the rest of the definition, we look at things prepared, owned by, or in the possession of a public body, its officers, employees, or agents in the transaction of public business. When we look at that stuff, generally prepared is easy. That's something we made it. Owned by is also usually obvious, but not always. Quick interruption. Celeste has a question about repeat the date by which current elected officials have to comply with the newest FOIA training requirement. That is December 31 of this year is the end date for that. Okay. Going back to the definition. So records prepared, owned, or possessed by public body, its officers, employees, or agents. When we say prepared, we made it, so that's pretty obvious. If we say owned by, usually that's obvious. Sometimes it can be legal ownership or constructive ownership. Sometimes somebody might hire somebody to do work on their behalf or farm out a job to someone else, but they still have a legal requirement to own it. Easiest example is hiring a consultant to do something for you. You're paying them for their work and their work product, you know, generate a report, give us an environmental survey, whatever it is. You've paid for that, you legally own it, even though it may actually be something they prepared or in their possession, it's still a public record that you own. Similarly, possession, important thing to keep in mind, you don't have to have prepared it or legally owned something for it to be in your possession. The easiest example of this is like a constituent letter or any other letter from a citizen to government about just about any government topic, because the next bullet point, transaction of public business. With my permit text this morning, you know, things like a neighbor reporting another neighbor for a code violation or building or fire, you know, code problem or local ordinance violation. The fence is over a certain property line, or the grass is too long, or whatever it is. Those letters, when they come into the possession of the public body, become public records. That last bullet point, draft versions are public records. That's just something to keep in mind. Just because you haven't actually used it for public business yet does not exclude it from being a public record. We're just looking at, is this something you made in the transaction of public business? And you got to keep in mind, if you are a government employee or official, anything you're doing for work as a government employee or official is public business. If you're doing it for some other purpose, okay, then it's not public business. If you're, you know, you get an email from your spouse saying, honey, I'm going to be late. By the way, I was going to stop at the store. Can you pick up milk today? You know, things like that, those are personal business. Those are private business. They're not public business. And so we're not going to consider them public records. But anything that is public business is a public record. And again, we'll mention social media again later, but you know, just keep in mind things like Facebook posts, Twitter posts, your email from a personal account, all that stuff can be public record if it's about public business. Okay. Debunking some FOIA myths. A lot of this comes from the name, freedom of information. It's not really about just information, it's about access to public records. And this is something that I think it was Allie was talking about it earlier, about answering questions, giving interviews, providing explanations, things especially in dealing with the police. And maybe if, you know, instead of saying, hey, we're not going to give you that, to say, hey, we'll give it to you, but we need to explain what you're looking at, or else you're not going to understand it in context. This is stuff, FOIA doesn't actually require that. It doesn't require you to answer questions, give interviews, provide explanations. But sometimes it is a good idea. You know, it's left up to you when you're going to do that or when you're not. FOIA just says you have to provide public records. FOIA does mention the word information, but information is a defined term. When used in the FOIA exemptions, it means information contained in a public record. Next, inspect or copy. Sometimes I've heard the public body saying, well, I'll let you look at that, but I won't give you a copy to take with you. There are some laws out there that provide for that. But the general rule in FOIA is it's the requester's choice. Requester can look at records or they can get a copy of records. And keep in mind, they don't actually have to say FOIA or anything. So when someone comes in and says, hey, can I look at those meeting minutes? Or can I get a copy of that report? Those are FOIA requests right there. And it's the requester's choice. Next big one, it is not free. Public bodies may charge, and we'll talk about charges in a little more detail in a minute, but freedom of information, it doesn't mean the information is all free. Public bodies are allowed to charge to recoup their costs. Next, I've seen a lot of things over the years where people say, oh, that's exempt under FOIA, so I can't release it. That's not really true. There are roughly something like 150 exemptions in FOIA and that are for records, and about 50 more or so for meetings. There are now a couple of prohibitions, and I do mean like 2 or so in FOIA that actually say you may not release certain records. And there are a number of other prohibitions outside of FOIA that say you cannot release certain records. But the FOIA exemptions themselves pretty much all have prefatory language that says the following records are exempt from mandatory disclosure, but may be released in the discretion of the custodian unless otherwise prohibited by law. And FOIA itself in the procedural section says, except as otherwise specifically provided by law, you must release records. So the default rule, again, you have to release records, and if it's exempt, it changes that default to a you don't have to release it, but you still can, okay? There are prohibitions, like I said, there are about 2 in FOIA and several outside of FOIA, but the majority of things you find in FOIA are not things telling you you can't release, they're things telling you you don't have to release. Last, as I mentioned, you don't have to say FOIA for a FOIA request to be made. FOIA specifically says you don't have to mention the name or the chapter in order for the rules to apply. FOIA therefore sets out the default. Anytime somebody asks for a government record and it is a public record, that's a FOIA request. It doesn't matter how they make the request. It doesn't matter whether they say FOIA. They don't have to put it in writing. They don't have to sign it. There is no difference between formal and informal. I have heard numerous times over the years, someone calls me up and says, well, I asked for this record from a public body and they told me that I needed to make a formal FOIA request. So I was calling you to find out how to do it. And I said, when did you ask for it? And they say, oh, yesterday. And I say, well, you made your request yesterday, because there is no difference between formal and informal. Okay, so keep that in mind. Now, on making a request, who has rights to make a request under Virginia FOIA? The law is pretty specific. It covers citizens of the Commonwealth and certain media representatives, specifically for newspapers, magazines, radio, and TV, with circulation or broadcasting in or into the Commonwealth. So who is not covered there? We do not cover out-of-state requests. We do not cover online media. We do recommend, however, that you go ahead and respond to those people anyway, because if you don't, all they have to do is get a Virginia citizen to make the same request. There's no reason, you know, for you to do it twice. Because if you say, oh, you're from Utah, I don't have to answer you, or oh, you're with CNN online and not regular CNN. You know, they're just going to get the regular CNN reporter. The guy in Utah is going to have his Virginia attorney, or he'll go to muckrock.com or FOIA Professionals or one of these other groups, because there are groups out there that are already advertising, hey, we will find a Virginia citizen for you to make the request on your behalf. Then you're going to do it twice. You said no to the guy in the first place. Now you got to deal with the citizen for the same request. However, we do note that if you're dealing directly with somebody out of state, it's really a contract matter at that point. You can reach an agreement with them on what you're going to do, what you're not going to do, because technically they don't have FOIA rights and they can't enforce Virginia's FOIA against you because of it. Now, how to make a request. First thing a requester has to do, and the main thing, is they have to identify records with reasonable specificity. On this point, we've given it a very practical interpretation. It means, can you tell what they want? Or at least, are you in the ballpark that you can ask a few clarifying questions, and you know, you might need to narrow the scope somehow, but you're in the ballpark, you know what they're going for. That said, volume alone does not mean something is not reasonably specific, because we're talking about the identification of the records, not the number of records. They can ask for as much stuff as they want. They can ask as many times as they want. Those are not limited under FOIA. So my classic example, and I don't think I saw her in this list, but I always do this with Holly from VDOT, and she's been in the audience, so she knows this one. If I went to VDOT and said, I want every report on bridge safety VDOT has done for the last 50 years, that would be a reasonably specific request. It would be absurd in volume. It would be incredibly huge, time-consuming, and expensive to actually try to sort through all that stuff for 50 years worth of bridge safety records. But it's specific in that they know what I want, they know what I'm looking for, and they can then deal with it from there. Okay. Next, a public body may require the requester's name and legal address. The law does say require. That was added after 9/11. Because of that, it can be a requirement. If you ask for it, they have to provide it. If they refuse, technically they haven't met their requirement in making the request. As I mentioned before, though, a request does not have to be in writing, and a request does not have to say FOIA. Also, the requester's purpose doesn't matter. The Virginia Supreme Court looked at that in 1988 and said there's nothing in FOIA that goes to a requester's purpose. It doesn't matter why they want it. Now, all that said, I always encourage people, you know, if somebody asks you for something routine and they don't want to give their name, who cares? If it's routine and something you'd give out anyway, just give it to them. Don't worry about it. On purpose, you technically, I suppose, you can ask why somebody wants something or what they're planning to do with it, but it doesn't really matter and they don't have to answer. On the other hand, I encourage requesters, especially if they're asking for records that are actually exempt and they're trying to convince the public body to release them anyway, then sometimes it's a good idea to say, oh, well, this is what I'm going to do with it. This is why I want it, because that may be enough to convince them to give it to you when they don't have to. Okay. And as I also mentioned, requester has the choice to inspect or to receive copies. Moving from asking for records to responding to the request, this is where in in-person training, I always hold up my hand. I like to remind everybody, if you have 5 fingers on one hand, you have a cheat sheet for FOIA right there. You have 5 working days to respond, and there are 5 responses to choose from. Okay, so 5 working days to respond after a request is received. First day is always the day after. So if you've got a request in today, tomorrow's Friday would be your day 1 to respond. Normally, we do not count weekends or legal holidays, so Monday would be day 2. I actually forgot it was Labor Day this Monday, so I was counting one out earlier today with somebody, and I counted Monday, and then he went, wait, we don't count Monday, it was a holiday, we were closed. Oh, that's right, you don't count last Monday because it was a holiday. Next, keep in mind, failure to respond is deemed a denial of the request and a violation of FOIA. This is something I know it was discussed a little bit earlier today about sometimes people just not responding to requests. This didn't used to be in the law. It was added because we were getting these situations, or this part was, but there was one of the responses is to say you don't have the records, and that didn't used to be in the law. It was added because we're having situations, various ones, but some of them, we get a requester saying, hey, I asked for these records a month ago, they never responded to me. I would tell them this provisional law says, well, it's deemed a denial and a violation, and they might sue the public body. And then the public body saying, hey, what are you suing me for? Those aren't my records in the first place. Of course I didn't respond. I never had those records. Well, you should still respond. And it was considered, normally common courtesy to just tell somebody, oh, hey, I don't have those. They're not mine. Somebody else might have them. It's not me. Well, because failure to respond is deemed a denial, we always encourage you to respond to every request, whether it's, even if it's an out-of-state request and you're going to deny it on the basis they're out of state, which we discourage. We think you should still deal with them and respond to them anyway. But even if you're denying it, go ahead and do it and actually give them a real response. Don't just ignore it. If you just ignore it, they may pull this and sue you. And again, they may not actually have rights, but they can still drag you into court to make you assert that. And nobody wants to deal with that. So make sure you respond to all requests. Next bullet point here, creation of new records is not required. This is where somebody comes in and asks you for something. The most common ones I see lately are things where somebody might have individual records, could be individual investigative records, individual personnel files, individual scholastic records, and the requester wants some sort of statistical or aggregate version that you simply don't keep or you haven't created. And if that's the case, you're not required to create it, but you may do so by agreement with the requester. This is a theme you'll find running throughout FOIA. It actually appears in the policy statement that public bodies and their employees and officers shall make reasonable efforts to agree on the production of records with a requester. It says the same thing here about creation of new records. So even though you don't have to, you can make an agreement to do it. You're always allowed to make agreements with the requester on the production of records. Anytime the default rules of FOIA are not going to work for that particular transaction, go ahead and make an agreement. A couple classic examples I have that are real. Somebody wanted architectural plans, he wanted a copy of them, but he wanted the full-size blueprints. And the public body didn't have a copier that could make a copy of that. And so they had to make an agreement to go get it copied somewhere else in full size. Same thing happened with somebody who wanted a laminated full-color version of like a 3-foot map. And they thought it was really cool. They saw it used at the public meeting and they said, oh, I want a copy of that just like that one. And I said, well, we're going to have to take it to the commercial copier and they can print one out for you. And I forget, it was 60 bucks or something like that. Requester agreed. Okay, then you go ahead and get it. But again, make your agreement with the requester for something like that. We do have a question here. Did you say if a request was received today that Monday would be day 2? Thought you didn't count the day the request was received. You don't count the day it's received. If it's received today, today is still Thursday. Is it not? I believe it is. Yep, it's Thursday. So tomorrow's Friday is day 1 and Monday is day 2. Okay. Yeah, click through that. All right. Next one. Talked about you have 5 responses. Quick versions. You have give them the records, say no, give them part of the records, say no to the rest, say you don't have it, or say we need more time to do it. Going into a little more detail. Okay, I didn't do the detail on this one. This is where the detail is in the other one for FOIA officers, but I will go into more detail just a little bit here. When you provide the records, that's all you have to do. I occasionally have people ask me, well, what about the cover letter? Or don't you have to sign it? There's no signature requirements in FOIA. There's nothing that says you have to create a cover letter when you respond by giving them the records. If you want to, you can. But again, consequence of choice. If you create a cover letter, you've created a public record because anything you do in the transaction of a FOIA response is a public record because that is public business. Got a new question. What if requester changes their mind and decides not to pay after the locality has made copies? Well, I mean, assuming you've sent them the copies and you can bill them and you can put the bill to collections just like any other debt. There's nothing special about a FOIA debt there. If they are billed, and we're cutting ahead a little bit to charges, but if they're billed and they don't pay the bill and it remains outstanding for 30 days or more, then you do not have to respond to new requests from that requester until they pay the old bill. Okay. And going back to the 5 responses. So as I was saying, with cover letter signatures, FOIA doesn't require that. If you do it, that's fine. Just keep in mind that you've then created a public record. I can tell you last time I checked the Public Records Act retention schedules on the Library of Virginia's website, records of a FOIA request are to be kept for 3 years after the last action in the transaction. So that cover letter will be something you keep for 3 years. Number 2 and 3 and 4 and 5. Anytime you say anything other than here have the records, you are supposed to make a response in writing. If you're withholding the records entirely, you have to cite the law that allows you to withhold the records. You have to identify the subject matter of what you're withholding, and you have to identify the volume of what you're withholding. If you are giving them part of the record and withholding part, then you still have to respond in writing. You have to cite the law that allows you to withhold the records, and you have to identify the subject matter, but you do not have to identify the volume. If you think about it, you know, if you're blacking out names and social security numbers and stuff like that, they can usually see what's missing, so you don't need to identify volume in that case. For the number 4 response, records could not be found or do not exist. That's the I don't have it. Again, respond in writing, and if you know that some other public body has the records, you have to provide the requester with contact information for the other public body. Sometimes people ask, well, you know, if I got a request by email, shouldn't I just forward the email? That's fine if you want to do that. It's a courtesy kind of thing. You don't have to. Technically, the law says provide the requester with the contact information. So sometimes you may want to, but you don't have to. For number 5, additional time. The basic rule is that if you need more time beyond the 5 working days, you can get up to 7 additional working days, but to do so, you have to respond in writing. You have to do that response in the first 5 days, and you have to specify why you can't make your full response within the first 5 days. So writing in the first 5 days that tells them why you can't do it. That'll give you the additional 7 days. It's additive with the first 5, so you get a total of 12 working days. Usually there's at least 2 weekends in between, so we're talking about 2.5 weeks there. If that is not enough time, the next step is to try again to negotiate with the requester. Up until a few years ago, we would tell you that 99.9% of the time requesters can reach agreements with public bodies and vice versa, because usually when these things require that much time, they're also very voluminous, they're expensive, there's a lot of searching involved, a lot of redactions involved, that kind of stuff. And so most people want to save time and money, and so they would negotiate on the scope. Sometimes they would trade, the requester would say, oh, well, I'll give you an extra week or 2 if you cut a little bit off my price, and you can negotiate on that. So there's lots of ways you could work out a deal. Up until a couple years ago, we almost never saw anybody go to the next step, which is if the 5 days plus 7 days are not enough and you cannot negotiate a deal with the requester, then the public body is allowed to petition a circuit court for more time. At that point, it's in the circuit court's hands, and they will tell you how much time you get. Like I said, it used to be we never really saw that happen. A couple of years ago doing trainings, I had someone from a state agency said they had actually had to file petitions twice in one summer because they just simply could not agree with the requester. So it has happened. It's still rare. I would say the vast majority of the time you can work out a deal. And there we go. A little bit about exemptions and redaction. As I said before, exemptions are not prohibitions. You may withhold things, but you can also release them if they're exempt. When something is exempt, like I said, you may withhold it, but if there's parts of that same record that are not exempt, you have to release those parts. There was a case that went up to the Supreme Court a few years ago. A lot of people were concerned that the way the court decided the case would have made it so people could withhold records even when an exemption only applied to part of it. And so we did a big bill that changed a lot of things in FOIA to make it very clear you can only withhold the parts that are exempt. Similarly, to withhold an entire record, it means the entire record has to be exempt. So we do give this kind of a practical interpretation. I've had some people say, well, that means you have to redact out, every other word except and, the, things like that. And that's just not practical. That's not realistic. So we don't go that far with it. But, if you have an email and 2 paragraphs are something that's exempt, and there's a 3rd paragraph that's not exempt, you have to turn over the email minus the exempt paragraphs. You can redact those, but you have to include the stuff that's not exempt. Okay, charges. The main rule, it says a public body may make reasonable charges not to exceed actual costs incurred in accessing, duplicating, supplying, or searching for requested records. It's important, almost every word in there has meaning. That's important when you look at charges. It's the public body that can charge, and it's the cost to the public body that we consider. We had a situation where an elected official wanted to charge his professional rate from his personal job outside of being an elected official. And so he wanted to charge something like, I think it was $155 an hour in order to process a FOIA request. Well, that's not what the public body paid him. Public body paid him something, I forget, $17 an hour or something. It was a much lower rate. And so we said, that's the rate you could charge because that would be the cost of the public body. You can't charge your private professional rate. When it says reasonable charges, this is one that I always encourage people, think sticker shock, put yourself in the other person's shoes and think to yourself, is this reasonable? Technically, law school answer is what is reasonable to an objective observer under the facts of a situation, but you're never going to know the answer to that unless a judge tells you. So to find out what is reasonable, there's got to be a lawsuit on a decision by a judge. So you never actually want to know for sure. But if you think sticker shock, you'll probably be in the right ballpark. For actual costs, this is something you can actually measure. So keep in mind, your upper limit is always your actual cost incurred to the public body. On the different things here, accessing, duplicating, supplying, or searching for requested records. In a paper world, accessing was generally opening a file cabinet. The most expensive version I've heard of would be going to an offsite storage facility to look through old records that are in some warehouse somewhere or something like that. In electronic world, the best examples I've had, and this will go back to what Josh was talking about, if you have to, he was talking about it with the state agencies switching the different email programs that they've used over the years. So let's say you want some emails, it might not be a whole lot of emails. You only want something for, say, 2 weeks from 3 different employees, but you want it from 2002. Well, I forget how many different iterations of email programs there were between then and now, 18 years difference. But how many people are still going to have that old program sitting on their computer or some other thing that will actually read it? Probably not many. How many still have emails from 18 years ago sitting on their desktop? Probably pretty much nobody. To find that stuff, somebody's going to have to be digging through some archives. You're probably paying some forensic IT person who gets paid quite a bit more than the average employee just to access those records and find them. So that's an accessing fee. Duplicating and supplying. Try to remind everybody, keep in mind paper world versus electronic world. Paper, you can compute costs for copying, putting stuff in an envelope or a banker's box, shipping fees, stamps, all that kind of stuff for duplicating and supplying. Electronic world, those things are usually nominal because normally we're talking about cutting and pasting or attaching something to email and hitting send. Sometimes there are actual costs in the sense of, you had to buy a flash drive and put stuff on it because it was too big of a file to send through email. And so you had to mail it on a flash drive or something. So there can be actual duplicating supply costs there. Sometimes there's timing involved, but normally the costs for duplication and supply are pretty nominal when it comes to electronic records, usually higher for paper. The last one is searching, and this is where we've seen costs skyrocket. When I did training earlier today, I was really dating myself because when I learned to type on a mechanical typewriter. If I wanted to make a correction, I had to roll the little cylinder up, get out my whiteout, paint the letter that I messed up, wait for it to dry, blow on it a couple times, very carefully roll it back to try to get my alignment correct, and then type my one little thing to do a correction and go back through. For anybody who remembers that, we didn't really do a lot of typing back then. There were people who were professionals at typing, and it was a very valuable skill, but we didn't do nearly as much typing as we do now. If you just needed to talk to somebody, you'd pick up the phone or walk down the hall. You wouldn't just go type, and run off a memo and give it to them every time. Whereas today, people send text messages and emails constantly all day long. And, you think nothing of it, but When it comes to the search time, this is where, and I'm going to use a real example that came in about an hour and a half ago that I'm going to need to answer here. Someone got an estimate, I won't say from who, but they wanted emails between 6 employees. I think it was for a month and a half time period. They got something like a $4,000 estimate because they're going to have to search through 70,000 emails is what they said. So yeah, 70,000 emails just for 6 employees for a month and a half. That's just a sheer volume issue. And that's where we're seeing costs go up and up and up. And I strongly encourage requesters and public bodies talk to each other. Try to work out things like keywords, narrowing the scope in any way you can to get to the records you want without incurring these huge costs, because the volume is just monstrous and it keeps going up. Couple new things here. The second bullet or third bullet point there, requester may request an estimate in advance. That's been in place for a long time, but as of July 1, we now have a provision so that when the public body sends the estimate, it stops the clock until the requester responds. That gives everybody a chance to actually negotiate. Before July 1, we had a problem where sometimes they would send an estimate, the requester wouldn't get it or would get it, later, but the requester for whatever reason didn't respond until after the public body said, oh wait, 5 days is up, I have to send these records. So they would send the records with a bill, but then the requester would go back and say, hey, wait a second, I never agreed to that estimate. I'm not going to pay this. And so you'd have a dispute over charges. So this gives everybody a chance to stop and negotiate. So that's why now it's send your estimate letter. That stops the clock. When they respond, the clock starts again. It works pretty much the same as the next bullet point with advanced deposits. Anytime the estimate's over $200, you can send a letter, which will stop the clock again saying, here's our estimate, and you can get a deposit up to the total amount of the estimate. When they respond by paying, then you go forward. Again, it's a chance to negotiate for everybody. Most requesters that I've dealt with don't want to pay large fees like that, and usually there's a way to negotiate it down. One of my favorite examples that I use a lot is from a few years ago when they were going to close down Sweetbriar College. A woman made a request to the Attorney General's office for all the relevant records and got an estimate, I think it was for $19,500, which of course, sticker shock. Do you want your records or do you want a new car? So she wrote, and you can read this in the Times Dispatch, she wrote to the reporters there and they wrote up an article about it. Well, she also talked to me and I talked to the AG's office a little bit. And what we found out is the way the request was phrased, it was going to require everyone at the AG's office to search their records. That was 200 or so support staff and about 400 attorneys. So I ask everybody to consider, if you could search all your records, everything you got in say half an hour, which is pretty much impossible for most of us, but let's say you could somehow do it, that would still be 100 hours of support staff time and 200 hours of attorneys time. You put all that together and that $19,000, 500 estimate doesn't sound so extreme now. It sounds like it's probably within actual cost. It might even be low. Well, the reality is they talked to the people with the requester. I mean, she talked to the AG's office, they talked to her, and they worked it out to narrow the scope of the request to the people actually involved and the correct time period and all that stuff. And so it was still expensive. I understand it was still a few $100, but that's much better than paying almost $20,000. Last one here, this is the one we already mentioned. If the bill, you've billed a requester and it's unpaid 30 days or more, then you do not have to respond to any new requests until that balance is paid. Okay. Got a question just came in. Is charging the time taken to gather info multiplied by the lowest hourly salary in the office okay? Yeah, let me talk a little bit about the salary issue before we move on. So on charging, we've always recommended, whoever is the lowest paid person that can do the work is the one you probably should have do the work. And because the charges, it says you may charge, you don't have to charge. You can always lower your costs. So if you want to set, we're going to set an hourly rate of however much time times whatever the lowest paid person is, that's okay. What's not okay, and we sometimes see is somebody wants to say, well, let's use an average rate instead because that'll balance out. Well, the problem with that is if you use your average rate and it's higher than the lowest paid person, but the lowest paid person actually does the work, then you've exceeded actual cost and you can't do that. So you can use your lowest rate, but you can't use an average or a higher rate for the default. The other thing is There are times when higher paid people are the ones doing the work, and I'm going to use the second bullet point on this slide. Attorney-client privilege is a classic example. There are literally hundreds of years of jurisprudence at common law going into attorney-client privilege. There are people who pretty much make their whole career out of, legal ethics, and part of that being what is privileged, what is not privileged. There are tons of examples. There are model rules. Different states have different rules. That can get extremely complicated. So if you have issues where somebody's going through and redacting something for attorney-client privilege, it's usually the attorney who's actually doing the work. In that case, that's a legitimate basis for them to charge their rate as an attorney. I would still encourage, if you're comfortable lowering that fee, lower it. That's good. If you don't want to charge, don't. Another example though, just because it's an attorney doing the work does not mean you should always charge an attorney's rate. This was a real example, and we as the FOIA Council chose not to charge, but somebody just wanted a copy of a call record. This was years ago. And so I literally flipped through a file cabinet for a couple months of call records and found everything with their name on it, went and made copies. I gave it to an administrative assistant and she sent it off. I'm not going to charge an attorney rate for that, even though I'm an attorney. All I was doing was looking for their name on a sheet of paper. An elementary school kid could easily do that. There's no need for an attorney's education or a bar license or any of that stuff. So I don't think that would have been a legitimate charge if I had tried to charge an attorney's rate. Okay, does that answer the question about charging with salaries and averages, I hope? I don't see any more questions. So moving on to the slide we're on here, exemptions of general application. Again, I don't think I can emphasize this enough. Exemptions are not prohibitions. So keep in mind, we're talking exemptions here. These are things you do not have to release, but you still can. General application, we call it that because most exemptions in FOIA are very specific as to both the type of record that can be withheld and the public body that's allowed to use the exemption. Like I said, there's something like 150 of them last time somebody counted that I heard. Most of those are very specific. There are some, however, that are general application, which means any public body can use these. So main ones we see a lot, personnel records, of course, the very first exemption in FOIA. General rule being if it's about an identifiable individual, you can withhold personnel records from other people, but you have to give it to the subject of the record. There are certain things that must be released. Most common ones: name, job position, salary and rate of pay if it's over $10,000, and allowances for expenses or reimbursements that are paid to any public official, employee, etc. Next two kind of go together: attorney-client privilege, legal memoranda, or work product. So attorney-client privilege is going to be records of written communications on legal matters with the attorney and the client. Legal memoranda and work product is prepared for use in litigation or an active administrative investigation. Again, usually the attorneys are involved with those ones. Next two, contract negotiations and procurement exemptions. I like to talk about these together because they're related but different. The contract negotiation one there at 3705.112 is for contracts that do not fall under the procurement laws. The other two are for ones that do fall under procurement laws. They're all very similar in that the basic idea is they protect things that might jeopardize negotiations or bargaining position up until the contract's awarded. They all do some version of that. The procurement exemptions have some specific timing rules about giving things to the bidders or offerers before they go to the general public. But generally, they all protect things up to the point that the contract's awarded, and after that, things become open. The biggest difference is with the procurement exemptions, they both have protections for proprietary records and trade secrets. They are worded differently. There are some very specific procedural differences. So if you have questions about those, I would encourage you to go ahead and contact us. Last one here, account and routing numbers. This is credit cards, debit cards, bank account statements, anything with a financial institution. Keep in mind, those records are generally open, except the account and routing numbers can be redacted. Okay. Moving on to the meetings section, we'll talk about procedures for closed meetings, open meetings, and electronic meetings. Again, just like with records, first thing to keep in mind is there is a policy that all meetings must be open unless they're closed following an appropriate exemption. We're going to talk about the definitions of what is a public body and what is a meeting. Then we'll do some procedural stuff on open meetings, closed meetings, and we're going to kind of lightly touch on electronic meetings. First definition of a public body. I call the first bullet point the traditional public bodies, the things everybody thinks of when they think public body. So legislative body, meaning General Assembly, the authorities, boards, bureaus, commissions, districts, or agencies of the Commonwealth, political subdivisions, cities, towns, counties, municipal councils, governing bodies, school boards, planning commissions, all the traditional stuff you normally think of. Kind of a subset of those, any committee, subcommittee, or other entity, however designated, of a public body, created to perform delegated functions of the public body or to advise the public body, is also a public body. This is something that, for some reason, it periodically just crops up now and then. People say, oh, well, we set up a committee of 2 and therefore it's not subject to FOIA. I have no idea where that idea came from, because a committee, subcommittee, or other entity, clearly, it's black letter, plain as day law. If it's created to perform a delegated function of a public body, to advise a public body, and it's created by a public body, it is a public body. I don't care how many people you put on it, other than 1, because 1 can't be a body. Definition of public body also includes other organizations, corporations, or agencies in the Commonwealth supported wholly or principally by public funds. Common ones here: tax-exempt organizations, some certain 501c3 charities, volunteer fire departments, rescue leagues, things like that can fall under this one. As a rule of thumb, we've said if it's 2/3 or more funded by public funds, that's a clear majority. There's no real argument there. That's going to be the principal source. On the other hand, it can be lower than that depending on what they do. I think the lowest one I've actually seen reported was a court case from a lower court where their funding was approximately, I think it was 51%, but they also were carrying out some government related functions. And so the court said, yes, we're going to rule that you are subject to FOIA. As I mentioned earlier, constitutional officers are specifically included in the definition of public body. That was following a court case that said they were not public bodies subject to FOIA. The General Assembly responded by specifically including them, but only for records purposes. So constitutional officers are not subject to the meetings rules. Definition of meeting includes work sessions. I'm going to stop there. I have people call up all the time, well, not all the time, but fairly often, say, well, it wasn't really a meeting, it was just a work session. Well, sorry, this is a quote from the statute. A work session is a meeting. Black letter, there's no argument. Okay, so work sessions, when sitting physically or through electronic communication means, as a body or entity, or as an informal assemblage. I'm going to stop there. Supreme Court back in 2004 looked at the word assemblage and this language about a body, entity, or informal assemblage, and said that implies an element of simultaneity. It means you have to be talking in real time as a group. It's not things that are separated in time like memos or letters. It is an actual assemblage. Next point, as many as 3 members or a quorum if less than 3 of the constituent membership. This is where we get meetings of 2 people. The general rule is 3 or more members. Everybody's probably familiar with that. The quorum if less than 3 means if you have 2 or 3 members on your body and your quorum is a simple majority, then the quorum is 2. And that's where you can have 2 members of a body be a meeting. So this ties back with what I was saying about committees, subcommittees, et cetera, where I've heard people say, oh, well, it's a committee, but it only has 2 members, therefore it's not subject to FOIA. That's just not correct. If you have a committee of 2 members, the quorum is 2, and anytime the 2 members discuss committee business, that's going to be a meeting, and it is subject to FOIA. Okay, moving on with the definition. Wherever held, with or without minutes being taken, whether or not votes are cast of any public body. This is where I remind people, if you have 3 members of city council or some other body, and you happen to run into each other at the produce line, and you're talking about the lettuce, that's fine. If you start talking about ordinances, you just turned it into a city council meeting. So be cautious of what you say, no matter where you are. Okay, I already did the next bullet point. Quorum for less than 3 means 2. And next, must be discussing or transacting public business in real time. Moving on, there are exceptions in the definition of meeting. The gathering of employees. So keep in mind, meetings rules apply to the members of the body. They generally do not apply to staff or other people. Gatherings where no part of the purpose is the discussion or transaction of any public business. So easy example, you're going to a ribbon cutting. Nobody's there to discuss public business. You're just saying, hey, we're now open for business for this building or something. You're going, somebody on council is receiving an award from the local chamber of commerce, and the other council members are just there to say, hey, congratulations. Okay, that's fine. But again, the caution, don't actually turn it into a meeting by discussing or transacting any public business. Keep it to whatever the event is that is not the purpose of discussing or transacting public business. Last bullet point, exception for public forums, candidate appearances or debates where the purpose is to inform the electorate and not to discuss or transact public business. That has a caveat that sometimes public business is the topic of the forum or the debate, but you're not there to discuss it with the other members. So the example of this, if you have a constituent running opposed and the opponent says, let's have a debate, and they agree to it and they go to the debate and you got the public there in the audience, and let's say the other members of the body are interested and just want to hear what they have to say. So they also attend in the audience. Well, as long as they're not transacting or discussing public business as a body, it's okay for the other members to be in the audience and listen while the other two debate the issues. Okay, so that's what that exception's for. It could also be, town hall, constituent group meetings, that kind of stuff. Okay, basic requirements for open meetings. You have to have notice to the public, it's got to be open to the public, and you have to have minutes. The notice requirements, you got to have the date, time, and location of the meeting. Those are the content requirements. That is it. People always ask me, well, don't I have to include the agenda? No, we have a separate rule for agendas. It does not have to be part of the notice. For local bodies, which is what this training is designed for, notice has to be posted in 3 places. One is the government website, if there is one. 2, my personal favorite, a prominent public location in which notices are regularly posted. This can be a number of different places, typically, town hall, courthouse, public library, someplace like that. I had one person tell me the best way in their small town was to put it on the corkboard in front of Food Lion. I said, okay, if that's where people actually see it, because the point is, get it out to the public. Number 3, this one's pretty easy, office of the clerk or the chief administrator of the body if there is no clerk. Continuing, there are different timing requirements depending on the type of meeting. If it is a regular meeting, you must post 3 working days before the meeting and you don't count the day of the meeting. So if we were meeting today, Thursday, we would not count today. We would go back to Wednesday, Tuesday, Monday would be our minimum. I would strongly encourage people, if you can post earlier than that, do so. 1, it's just good policy. 2, I've had people question, well, the meeting was held at, I think, 1 p.m., but they didn't post the notice until 3 days before at 3 p.m. and therefore it was 2 hours short. Technically, I don't think that actually works. Legally, a day is a day and part of a day is still the day. So it doesn't really matter if it's an hour or 2 off legally, but why go through the hassle of having that challenge if you can just post an extra day early? If I can post on Friday for a Thursday meeting, then there's no question that I posted in time and everybody gets to see the notice. So try to post early if you can. For special emergency or continued meetings, they're all different types of meetings, but they have the same rule with 2 elements in it. 1, it has to be reasonable under the circumstance, and that, of course, varies with the circumstance. Typical example, my personal favorite is, let's assume I'm your attorney and I just won the lottery. We've got court tomorrow, but I won $300 million and I don't care now. You can disbar me. I'm going to move to Hawaii tonight. Well, if I do something like that and, I call you up and say, hey, sorry, I won the lottery, I'm leaving. You're going to have an emergency meeting to get somebody to represent you in court the next day. There's almost no time whatsoever to do anything. You're going to call that meeting basically right now. On the other hand, if I was your attorney, won the lottery, I'm going to move to Hawaii, all that stuff. But I say, hey, we don't have anything pending right now. Next court date is a month and a half away. My coworker here is very well versed in this, and I think you should hire her to replace me, but it's your decision. I'm giving you a month's notice. Well, if I give you a month's notice, you can at least do a 3 days notice before your meeting. You've got the time. The notice, like I said, it varies depending on the facts. Last one there, public notice must be posted at the same time the members are notified. And that's where I like to emphasize, usually the enabling statute for whatever body is will have specific rules about notifying the other members, calling meetings, that kind of stuff. That does not cover the public notice. FOIA addresses the public notice and says whenever you notify your members, you also have to notify the public. Very last bullet point, direct notice to those who request it. Typically these days, that's almost always by an email list. Like the FOIA Council has one that's automated. You can just sign up anytime you want to. There are specific provisions in the law about them providing their contact information, et cetera, and it says you can notify them by email unless they object. Used to hear from people sometimes who didn't want email and they got snail mail, and that lasted up until they missed a meeting because the mail was late. And then they said, okay, give me email. So these days, I don't know anybody who asks for anything but email. So that's typically just post your notices, make sure you post your notices to your members. At the same time, you notify the public and go ahead and shoot it off to your email list at the same time. Okay, what does it mean for a meeting to be open to the public? It literally means open to the public. They can come in. If you have a situation with locked doors and the public can't come in, that is not an open meeting. I have had a situation where somebody called me out and said that town halls usually open before meetings, so they had a member of their local citizens group who would go early, and he'd eat at the local diner, then he'd go over to town hall, sit down and hang out for the meeting. And one day he went over, the doors were all locked, he couldn't get in. He went around the building, he found members of the town council were sitting around a table talking with each other. So he banged on the door till finally the town clerk came up and said, "I'm sorry, I'm gonna have to ask you to be quiet. There's a meeting in progress." Well, that was pretty much a clear violation because one, it wasn't open to the public because the doors were locked. And two, they actually were starting their meeting before the time that they had put in their notice. So that was also a violation. With open meetings, there's also a rule that says you have to allow the public to record, photograph, film, or otherwise reproduce it. And you cannot meet in a location where that is not allowed. Specifically, a couple public bodies were meeting at a courthouse, and the courthouse, for security reasons, did not allow people to bring in cell phones or cameras or anything like that. So there was a problem there. Potentially, the General Assembly's decision was you're not allowed to meet anywhere where you cannot have those forms of reproduction and recording the meeting. Next one, this was mentioned earlier. FOIA does not address logistics such as room capacity, but especially in light of COVID-19, everything going on right now, we strongly encourage you, do everything you can to increase public awareness. Use live streaming, broadcast over local TV or radio, post recordings of your meetings, which is part of the requirement if you're meeting using the budget language. Anything like that that lets people know what you're doing is a good thing. I think I heard earlier someone was saying about a state body that met and they were only allowing 9 people into the room, and it was first come, first serve, and then nobody else got in and they weren't live streaming or anything. That's one of those situations where I'm gonna have to say it's not a technical violation since FOIA does not address the logistics of it, but in the spirit of FOIA, if you have the capacity to increase public awareness to what you're doing, you should. Next, meeting minutes, only required to be taken at open meetings, not at closed meetings. They have to have date, time, location of the meeting, just like the notice requirements. Then you also have to include members of the public body present or absent. And then the fun one, a summary of matters discussed, deliberated, or decided. It is up to you, your discretion, your public body's policy, if any, about how detailed you want to make the summary. I do encourage you, include the main gist of things that are said, decisions made. You do have to record any votes taken, and specifically any motions to enter a closed meeting and certifications of a closed meeting have to be included in detail. But with summaries, you don't have to do a verbatim transcript. Again, caveat, if you're meeting electronically under the new budget language, you do have to have a recording or a transcript, but that's only under the budget language. Otherwise, you do not have to do a verbatim transcript of what's going on. It's just a summary. I do encourage people, when you have public comment and stuff, like we actually have put up all our public comments lately that we receive in writing, they go up on the website. We didn't get any live comments at our last meeting. If we did, I try to always mention who the speaker is and whether they spoke for or against something. I don't necessarily include every detail, but you want to put something in there to let people know. All right, moving on. Agendas. As I said, FOIA has separate agenda requirements. Says you have to have at least one copy of it available for public inspection at the same time materials are furnished to the members. So if you give out your materials to your members a week before the meeting, you would also have to have one copy available for the public to look at when you do that. If you don't hand it out until the day of the meeting, then technically you don't have to have the extra copies until the day of the meeting. Typically that's what we would do at the FOIA Council, but as a practical tip, everybody looks online these days for stuff. FOIA does not specifically say you have to post your agenda online, but it's a good idea. Same with your agenda materials. If they're not exempt, post them online, and the earlier you can get them up, the better, because then most people will go find them there and you won't have to print as many extra copies. You won't get as many requests for them because they'll just find them on your website and that'll take care of itself. Next, I did want to note, FOIA does not address things like agenda changes, doesn't require specific things to be included or not included on the agenda. doesn't address matters of parliamentary procedure. Those are all things covered under, they might be under bylaws. Somebody might have adopted Robert's Rules of Order or some other thing, like the General Assembly uses Jefferson's Manual. If you've done that, that's fine, but it's not the same as FOIA. FOIA doesn't cover those issues. On that point, I do get a lot of things where people send me an agenda and say, look at the closed meeting motion here in this agenda. That doesn't comply with FOIA. And I have to tell them, if that was the actual motion, maybe you're right, maybe you're wrong, depending on what it is. But since it's only written on the agenda, that's not really the one that counts. What counts is the actual motion that's made. Something included on the agenda, FOIA doesn't require you to put a closed meeting motion in an agenda. It doesn't even have to be there. That's something that would be covered under parliamentary procedure, not under FOIA. All right, since I started talking about closed meetings, let's go into it. Motion, discussion, and certification. First thing, the motion has to be voted on in an open meeting in order to convene a closed meeting. So before any closed meeting, you always have to have an open meeting first. So that's the first thing to do. You can have your meeting with an agenda that says something like, okay, open meeting, call to order, closed meeting, first item of business. That's fine. I mean, it may be 30 seconds or a minute after you call it to order that you make your motion, you vote on it, and you go right into your closed meeting. You can do that, but that motion and vote has to be done in the open. The motion has to have three things in it. It's got to have a subject, a purpose, and a site. If you look out at 2.2-3711 in the code, it's got prefatory language, and I've got it up next to me, so I'm going to read it to you. 2.2-3711A, public bodies may hold closed meetings only for the following purposes. And then it lists out all the different exemptions. For that reason, when you quote or paraphrase the exemption itself, that states the purpose, but it does not identify the subject matter of the closed meeting. When you go to 2.2-3712A, it specifically says, a general reference to the provisions of this chapter, the authorized exemptions from open meeting requirements, or the subject matter of the closed meeting shall not be sufficient to satisfy the requirements for holding a closed meeting. So remind everybody, if you quote your exemption and give the code site, that gives you number 2 and number 3, the purpose and site, but you got to do something more to identify the subject. We've always said it has to be more than what's in the statutory language, but not so specific as to defeat your whole reason for holding the meeting. Okay, with closed meeting discussions, keep in mind, you can only talk about the things you identified in your motion and that are allowed to be discussed in closed meeting under FOIA. Minutes are not required. If they are taken, they're exempt from FOIA, but as Maria always reminded people, they may be exempt from FOIA, but that does not necessarily mean they're exempt from a subpoena. So if you take minutes, again, this is another consequence of choice. They're not subject to FOIA, but there's still a record there and someone could subpoena it, so keep that in mind. Next, about closed meeting discussions, who may attend? It's assumed the members of the body can always attend. Non-members can also attend if they're necessary or they're going to aid the consideration of the topic. And then if you have a situation where, for example, a town council has a committee, so you have the parent body as the council and the committee is the sub-entity. If a member of council who is not on the committee wants to attend a closed meeting of the committee, they can, but they are not allowed to participate. So they just have to go there and listen, and that's it. They cannot participate at all in it. And this is things, where the members of the main body say, oh, I'm really interested in what's going on here. I want to stay apprised of the issues, but they are not allowed to participate or make decisions because they're not actually on that committee or subcommittee. Last, certification of a closed meeting. At the conclusion, you have to certify the only things heard, discussed, or considered were the things lawfully exempted and that you identified in your motion. As of was it a year ago, I guess, there is an extra penalty for improper certification. We have not seen that applied yet, but that came about, I remember from the committee testimony, there were numerous instances across the state at both local and state level where people had certified closed meetings and then later came out and said, oh, I think we did that wrong. We actually strayed off topic. I probably shouldn't have certified. And for that reason, the General Assembly wanted people to take it very seriously and really consider it, because the FOIA already says if you think you strayed off topic or there's some other departure from the closed meeting requirements, you're supposed to make a statement to be included in the minutes before you vote on the certification. So you're supposed to do that. And I would remind people, if you do have a problem with something that happened, do make that statement. Otherwise, and I've seen real minutes that just say things like member X left the meeting, or member X voted to enter the closed meeting, and then member X had to leave during the meeting. Doesn't say anything about why. If you don't make that statement, there's not necessarily going to be anything saying that you felt there was something wrong with it. People may assume, oh, you got sick, or you had to go for a, some other appointment, you had a scheduling conflict. It could be anything, but nobody's going to know you thought there was something going on that was wrong. Voting. All votes have to be taken and recorded in an open meeting that is conducted in accordance with FOIA. You are not allowed to have written or secret ballots, so no voting by email. You are allowed to have straw polls or to reach consensus in a closed meeting, but any decision made in a closed meeting is not effective until you vote at an open meeting. So remember, for a vote to be effective, you always have to vote in an open meeting that was conducted properly according to FOIA. Like we did with records, some common exemptions. Again, personnel is the first one in the meetings exemptions, just like it's the first records exemption listed. It is a little bit different in application and how it works, but it's basically still the same concept of protecting individuals' privacy. Next one, scholastic records, and talk about students. After that, acquisition or disposition of real property. For that, I like to remind people there was an old version of that exemption that talked about the condition or use of real property. So you can find some old opinions, court cases and stuff talking about that. That was taken out, I believe it was in the 90s when they removed that part. So if you own a property and you're talking about repurposing it or reconditioning it or something, that is not a closed meeting topic. If you're talking about buying, selling, or leasing property, that's acquisition or disposition. Those things are closed meeting topics, but if it's just repurposing, reusing, discussing the condition, changing an old school over to a community services building or something like that, that is open meeting discussion. Next, discussion of prospective business or industry. This is one where if an announcement has been made that the business or industry is interested in coming to your area, then you can't use the exemption. So necessarily the motion for this one is usually pretty vague, but otherwise, it's commonly used, and I would encourage people, try to be as specific as you can with it. And that's kind of the case with all these, because you need to be more specific than just saying the exemption. For this one, I use examples. We had the Rolls-Royce engine plant that I actually just read is closing down, at least temporarily, if not permanently, but it opened up a few years ago. It was a big economic development deal. It was very hush-hush and quiet. So if you were having a meeting on something like that, you might say a manufacturing industry or transportation industry. You're not going to say Rolls-Royce. You're probably not even going to say engine plant, just to preserve the use of this exemption by not making an announcement. Next two, actual probable litigation or specific legal matters. Keep in mind with actual probable litigation, probable is defined. This means you actually either have filed litigation or someone's filed against you. Probable litigation is where you know who would file it or who you would file against and why. It is not possible litigation. If you're just going, ooh, if we do that, maybe somebody might sue us, maybe. Well, that's not a closed meeting topic. It's got to be probable where you actually know who would sue you or you would sue and why. Also with actual or probable litigation, you don't necessarily have to have your attorney there. It also includes briefings by staff members. For specific legal matters, that again, it has to be specific, not generalized stuff, but with that one, it is consultation with legal counsel, so your attorney has to be there. Next one on public safety issues, keep in mind the way this one is phrased, it deals with things like building security, terrorism, counterterrorism kind of stuff. It is not just for general updates from the police. We see this periodically where there may be a matter of, general interest or curiosity as a criminal matter that's going on somewhere, and the police chief wants to update the town council or something like that on it. There's no real exemption for that stuff. There isn't just a generalized, police matters or criminal matters. This is specifically public safety. Last one, discussion of award of public contract. This one has been interpreted by the Supreme Court. They're talking about procurement contracts. And if you have questions about that, I would encourage you to give me a call. It is different than on the records side, where records we talked about, there's a generalized contract exemption, and then there's the procurement ones. The ones under the meetings rules are a little more specific. For example, the real estate one is one for real estate. This one is one for procurement. There are different ones for different purposes. Real quick, because we're running out of time, electronic meetings. As of 2020, we've got 6 processes, 5 are in FOIA, 1's in the budget. 4 of them can be used by any public body. The other 2 are for regional bodies and state bodies only. For local bodies, you can participate electronically if a personal matter or medical condition prevents your attendance. Both of those will require that you have a quorum in place physically. There has to be a participation policy that's fair to all the members, and the remote member's voice has to be heard at the main location